So we're just going to jump right into it. This one says Arizona mom charged with stopping her underage son from being able to breathe, is how I have to say it because we're live on TikTok.
You what?
This sounds crazy.
An Arizona real estate agent is out on bond after police accused her of violently beating her
Oh my God.
stepson. She's facing multiple charges, including child abuse and aggravated assault. We're combing through her indictment and getting an Arizona attorney's perspective on this case.
My God, you can burn in hell for that.
Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. So we have these new charging documents out in Arizona, and it gives us some insight into a terrible case, although we don't have a ton of details, but we're going to tell you what we do know, and we're going to try to make sense of it. So Ariana Anzuris is a realtor in the Maricopa area, most recently reportedly working for Adams & Company's Real Estate's Arizona office. According to the Pinal County Sheriff's Office, Anzuris was arrested at the end of July and indicted by a grand jury on 4 major counts: child abuse, 2 counts of aggravated assault, and disorderly conduct. Now, I want to go through why she is charged with each of these counts, and to help me do that, let me bring on Arizona attorney Kurt Altman to talk about this. Kurt, thanks so much for coming on. I got to tell you, the first thing I'm shocked at, there's like no information about this. There's no reporting that I could find. We have this document that we'll get through, but don't you find it strange that it doesn't feel like it's being talked about more?
Well, first of all, Jesse, thanks for having me on. Sorry that it's, about this subject, but to answer your question, when a child is involved, it is pretty unusual that we haven't gotten more coverage, more media coverage. I've tried to look up some of the details on this case and can't find a lot, which is kind of different, actually. Certainly the child's name, if they're under 15 years old, is going to
that is crazy as hell.
Be withheld. They're not going to say who it is, but we're still going to hear the facts or the allegations at least, and we just haven't heard too much.
I found like one article that was maybe sort of about the community and talking about, hey, have you worked with this real estate agent before? Or worked with this realtor before? And kind of went through some of the allegations, but that was it. I find that kind of strange.
Y'all, look at the Facebook name. You see up there on the top left? That's her Facebook username.
About what we're about to get into. So if we take a closer look at this grand jury indictment, the victim is not identified, only referred to as DS. And I want to go through these now. So count 1 is child abuse, and it reads, according to the indictment, quote, on or about July 28th, 2024, under circumstances likely to produce death or serious physical injury.
Jeez.
She
entertainment and educational purposes only, TikTok overlords.
Intentionally or knowingly did cause DS, a child under 15 years, to suffer physical injury, to wit, restricted victim's airway and or circulation. The state further alleges that
oh my word,
the offense charged in this count is a domestic violence offense. The state further alleges that the offense charged in this count is a dangerous crime against children. So, Kurt,
my God, you're going to burn in hell for that, lady. TJ, howdy, ma'am. Thank you.
Adding what seems to be aggravating factors mean for this defendant?
Well, it's really all has to do with the potential sentence, Jesse. The domestic violence allegation is an extra allegation that the state would have to prove, but that will enhance, if proven, some potential penalties in the end. And then, of course, this person, the defendant, would be designated as a domestic violence offender forever if convicted.
Whoa.
The important thing is the dangerous crime against children. Under Arizona statute, what that does is when there's allegations such as this that are this significant to a child under 15, totally changes the sentencing scheme in Arizona and makes any penalty for this crime super, super severe. In fact, if convicted of a dangerous crime against children, it's what we call flat time in Arizona. You don't get 85% time if you go to prison. You can't get early release. You can't earn release credits. You do, if you get 17 years, you do 17 years to the day. If you get 21 years, you do 21 years to the day. And that's only available for a couple different types of crimes in Arizona.
Oh, wow.
By the way,
good though.
We're in August right now. I have to tell you, sometimes, and we don't know the circumstances of who reported this or how law enforcement came to know about this, but the fact that this happened just now and we have an arrest, we don't usually always see that in child abuse cases. So when you look, sometimes it could be something from 6 months ago. It could be from a year ago. And the fact that this seems to have been reported is very significant. So quickly, I mean.
Yeah, I think that's, yeah, I mean, I think that's right. I would imagine that's because the law enforcement believes they have significant evidence and enough evidence already to convict. Often a child abuse case, the only people that know what actually happened in a child abuse case are the person accused and the child, who often can't testify, who is often too young if it's a baby that's been shaken or abused. So it does take some significant time to investigate and evaluate those cases. That's not the case here. So
it's her stepson too, y'all. That's crazy as hell. Ryan, no, but if you go watch the video, it got me too.
It would be interesting to find out more about the facts and the evidence that law enforcement has.
All right, so now let's move on to count 2, aggravated assault. Quote, intentionally, knowingly, or recklessly did cause physical injury to DS. And
oh, Lord, y'all, her name is Ariana Cheyenne Azurez. She's from Arizona. She's like an Arizona realtor that, like, apparently, allegedly went in on her under 15-year-old. They didn't say exactly how old, but under 15-year-old stepson.
How dare you?
This is crazy as hell.
Ariana Cheyenne Azurez intentionally or knowingly impeded the normal breathing or circulation of blood of DS
and tried to stop him from breathing
by applying pressure to the throat or neck, or by obstructing the nose and mouth either manually or through the use of an instrument.
You'll burn in hell for that one.
DS is the child of the defendant's spouse and lives in the home. Then count 3 is another aggravated assault charge, and it says that she, on or about July 28, 2024, being 18 years of age or more, intentionally, knowingly, or recklessly did cause physical injury to DS, a minor under 15 years of age. Kurt, why charge both counts of aggravated assault here?
Sure, Jesse. The 2 separate aggravated assaults for 2 separate acts, I guess, 2 separate courses of conduct. The first one is the more significant one as far as penalties. That's what's called a Class 3 felony, very high felony in Arizona. And interestingly, they said either manually, obviously they think that the defendant strangled or tried to choke this child, or with an instrument. The instrument in that charge is interesting because use of an instrument, or say a pillow in a case like this, or a bag, or anything that could cause suffocation, can be considered under the law a dangerous or deadly weapon. And if they can prove that it's a dangerous or deadly weapon in the manner that it was used, again, we're talking about significant mandatory prison time. Presumably, this is her first felony offense. If that's the case, typically you're probation eligible. Well, that dangerous offense, forget about the dangerous crime against children for a minute. That dangerous allegation on that aggravated assault takes any idea, any possibility of probation away. And again, she faces significant amounts of time in prison. The second aggravated assault is a lower level felony, and it's basically when anybody that's over 18 assaults and hurts, causes injury to a child under 15. Still a severe child abuse case or aggravated assault case, but not as severe as the one with the deadly weapon or dangerous instrument.
Let me ask you this. The fact that she is being charged, and we haven't gotten to the last charge of disorderly conduct yet, but charged separately with these individual offenses, would that lead you to believe that if this goes to trial and she is convicted, that a judge would sentence her consecutively for each one after the other or concurrently? I have to imagine when you're dealing with such a sensitive case like this and you're dealing with horrific child abuse, it is the incentive of the prosecutor to try to get as much punishment as possible here. And they would want this running consecutively, meaning each sentence for each charged run one after the other. Would I be right about that?
Well, in Arizona, it's certainly, she certainly faces consecutive sentences in something like this. And that's entirely up to the court at sentencing. The court could look at it as one course of conduct and one victim and not impose consecutive sentence. I mean, I would say the majority of sentences around here are concurrent sentences for multiple counts on one occasion. However, in a case like this that's this severe, that's not always guaranteed. Again, with the dangerous crime against children, we're looking at significant amounts of flat time. I think that probably tops out right around 24 years. So 24 years, day for day sentence is pretty significant.
Whoa.
If a judge were to add a consecutive sentence, it'd basically be a life sentence.
And would you also say that for a prosecutor, they are trying to throw as many charges as they can, not saying, that the allegations don't deserve it. But if there is a fault in the language of one of the crimes, if the jury comes back and says, you know what, I don't think it meets the elements of this, but it might meet the elements of this, you want to make sure you have something the jury will ultimately find her guilty of.
I think that's exactly right. Whenever you walk into a case with a child as a victim, it's a very uphill battle for the defense. So the fact that the prosecution adds all these charges, I think, is significant for the reason you said, and also significant for the types of evidence they can get into trial. With the different charges, if a defense lawyer were to say, hey, this act or this piece of evidence is not relevant to this charge, they'd be like, well, it might not be relevant to the dangerous crime against children, child abuse, but it's certainly relevant to the disorderly conduct. So we can get into her conduct, other evidence. So it's going to open up the doors to just, and I don't mean this in a bad way, exactly the way you said, but opens up the doors for them to pile on, just bring in all the evidence and really show the jury what happened that day.
By the way, do you think it's significant, and we haven't gotten to the fourth charge yet, do you think it's significant, or what does it tell you?
Alexa, thanks for the follow.
Or how does it affect the case that this was apparently her stepchild?
I mean, obviously it's significant. They live in the same household. It's a stepchild, so that's why it's the domestic violence allegations on there. But I think certainly when it's a step parent and stepchild, just out of human nature, I think juries are going to look at this a little bit differently and look at the motive and the intent of the defendant a little bit differently than if it was a biological child. It's just the fact of how people look at things. So
I can't believe she would do
I think it's significant.
That's crazy.
Okay, so then we have count 4.
By the way, y'all, her name is Ariana Cheyenne Enzurez. So it's like this, because I see a bunch of people in TikTok saying, who's this about? Who's this about? She's like a realtor in Arizona, and supposedly, allegedly, she went in on her little stepson. Crazy.
We have disorderly conduct, and this is interesting because it says that she, quote, intentionally or knowingly did disturb the peace or quiet of a neighborhood, family, or...
But the child lived, y'all. The kid is alive.
Person to wit. DS...
Well, that's good, at least, but yeah.
By engaging in...
Yeah, it was a little... I think it's a little boy, stepson.
Fighting, violent, or seriously disruptive behavior. And according to the sheriff's office...
Cheryl, how do man
she was apparently drunk at the time of this alleged attack, showing blood alcohol results that were more than twice the legal limit when she was given a breathalyzer. And deputies also say that the child's biological mother provided audio and video evidence of this alleged attack to law enforcement. So now we're getting a sense of what kind of evidence prosecutors might have. What are your thoughts on that?
Hell.
It's kind of another throw-in for the prosecution that allows them to bring more evidence in my opinion. Disorderly conduct is a felony, low-level felony, but based on the charge and what you're telling me and what the indictment says, sounds like people were just having an evening, an afternoon, whatever at the house, and she instigated this because she was drunk. She disturbed the peace and quiet of somebody else. And the fact that the prosecution charged that, I think they'll be able to tell the entire story. DS was sitting around, they were watching TV, whatever it may be, they'll be able to get into a lot of the conduct of the defendant that took place prior to the actual assaults. And I think that charge is very important for that, just to open up the entire story and make sure the jury hears everything.
I mean, if you have video and audio evidence of this occurring too, again, it feels like a very, very strong case. You mentioned the strength of these kinds of cases in general. But having said that, not every person who is charged with child abuse or aggravated assault of a child is found guilty. And I am curious, what are potential defenses that someone in her position could mount? And I know it's tough because you don't know all the details of this case, but what are some defenses that we see in these kinds of cases?
It depends who was there. Obviously, it sounds like there were some other people there, or there was an audio video. So that's
oh my God,
going to be harmful to the defendant. But often in a child abuse case, again, children get hurt and people are charged with abuse. But the only two people that are generally there are the child and the alleged defendant or the defendant. And it's kind of a he said, she said sort of situation. So you really have.
Oh Lord, didn't get notified. Can't recap. So this girl, Ariana Azurez in Arizona, she's an Arizona realtor. She like apparently was drunk and like attacked her young stepson and almost unalived him.
Have to look at the physical evidence in order to prove that case. And as a defense lawyer, you really want to attack that physical evidence. Maybe in this case, DS had some strangulation marks or something around his or her neck. You're going to look for medical experts. You're going to look for other opinions to come in and say, yeah, that could happen this way, but it also could have happened this way. Just to put some doubt into the jury's mind and give them some other versions of the events, potential versions.
And I am curious how this plays out because she was released on a $25,000 bond, and according to the sheriff's office, she could face maybe almost 20 years in prison. You mentioned that if she's convicted.
20 years in prison.
Convicted on all the counts. Since her arrest, though, she has been removed from a listing of agents on the Adams and Company real estate website. Not
I wonder why.
How do you see it playing out? Because I always ask this question when it comes to child abuse cases. Is there an incentive not only on her part, but also the part of the prosecutors to get a plea deal? Why? Because I think particularly in these cases, if you can prevent a jury and the community hearing this evidence, if you could prevent DS from having to testify about what happened, I think everybody's better for it. So what do you think the incentive for a plea deal would be here that wouldn't absolve her of responsibility? Because these are very, very serious allegations. But at the same time, to spare everyone the time, the expense, the heartache, the pain of going through a trial, what do you think the likelihood of a plea deal is here?
I mean, what I think just in general, 90 plus 95% of cases plead. I think there's incentive on both sides in a case like this. One, the defendant, obviously, if that conduct took place and there's strong evidence that that they can prove that conduct, she's looking at a ton of time. So obviously they're incentivized to try to work out a deal that's best for them to preserve some of that time so she can get out of potentially prison with a life to lead. And from the prosecution standpoint, they have to do the just thing. They have to determine what is really best for the victim and the community. And with that, you do think of the collateral consequences and the collateral things. Do you want to put DS on the stand? Is this child old enough, 14, 13 years old, that they would have to testify?
That doesn't look like a 14 or 13-year-old in that picture right there. They blurred the face out, but that looks pretty young. That looks 9, 10 maybe.
And what kind of trauma would that cause to that child to walk in a courtroom in front of a jury, testify, be cross-examined by a defense lawyer? So the prosecution is going to take all those things into account and say, we think a just result in this that's going to protect the community, get some consequences for the defendant, and protect the victims is whatever. So they have a strong incentive to plead these cases.
Kurt Altman.
Oh, I bet.
Thanks so much for coming on, and it was great seeing you. But as you said at the beginning, wish it was under different circumstances, but great seeing you. Thanks so much for coming on.